Welcome to Audit the Courtroom for viral USA court cases. This case opens with a defendant who already knows the system, and that's what makes this courtroom moment so intense. We're dealing with Denzel Spikes, a man already on probation for aggravated assault with a deadly weapon, now standing before the court again for committing the same type of violent offense. And right from the start, you can feel the weight in the room. This isn't just another plea hearing. This is a test of accountability, credibility, and whether probation actually works when violence repeats itself. The judge is methodical, calm, and precise, but don't mistake that for leniency. Every document, every prior case, every fact matters here. The prosecution references mutual combat. The defense suggests the new offense wasn't as severe, but the judge is already connecting the dots. Same behavior, same danger, same pattern. And that's the real question hanging over this courtroom. How many chances does someone get when deadly weapons are involved? Because what you're about to see isn't just sentencing, it's a reality check. Stay with us, because the judge's reasoning here sends a message far beyond this courtroom.
Denzel Spikes. Okay, you're Denzel Spikes.
Yes, ma'am.
Will your client waive the formal reading of the motion and the indictment?
He does, Judge.
Judge, we're just proceed on count one, on allegation number one, we'll ban the rest. That is the condition.
Mr. Spikes, in cause number 25 DCCR 0921, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from April 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents in that case that have your signature on them that the state's marked as exhibit number 1. I'm going to need some explanation.
On
The punishment,
his 3, Judge,
he's on probation for aggravated assault with a deadly weapon, commits another one.
the newest one was not as egregious as it seems. It was a kind of a mutual combat, but
Okay, let me look at the,
we're proceeding on that with the lower offer due to the nature of it, but not to continue him on probation.
okay, give me a second. So give me just a second, I'm going through a couple things. Okay. All right, so I have, again, some paperwork here that has your signature on it. Did you go over that with Mr. Lewis?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Look at one more thing before I do this. Let's see, 24. I'm printing something. Bless you. I'm just looking now at the PC from the original case. I'm looking at the PC from the new case. Let me see if I can go back. I'm also gonna take a look real quick at the PSI. I'm just not feeling real comfortable with that low. I understand in the new case, potentially some issues if there was some mutual combat, but the underlying offense and the fact that we're resorting to the same thing and grabbing things and beating people with them is concerning. No criminal history. All right, state tenders number 1 in 25 DCCR 0921.
No objection, Judge.
It's admitted. Any evidence Mr. Spikes is not competent?
No, Judge.
All right, sir. In cause number 25 DCCR 0921, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term.
This is the moment it becomes very real. The judge formally accepts the guilty plea and sentences Mr. Spikes to 3 years in the Texas Department of Criminal Justice. But that's only half the story, because immediately after, we transition into the probation revocation hearing from his prior case. And here's the key. This wasn't a new trial. This was about whether he violated the terms of trust the court already gave him. When the defendant pleads true to committing the new offense, the outcome is almost inevitable. The judge revokes the deferred probation and imposes another 3-year sentence, plus an affirmative deadly weapon finding in both cases. That finding matters. It affects parole eligibility, firearm possession, and future sentencing exposure. This is a textbook example of how one bad decision can trigger multiple legal consequences at once.
To a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1642, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges in the state's elected to proceed on count 1 only. It alleges that you committed the new offense of aggravated assault that we just with a deadly weapon, the one that we just went through, April 29th of 2025. And is that true or not true?
Sure.
Did you enter your plea of true to count 1 freely and voluntarily? And did you plead true to that count because it's actually true? I have here on the tablet also some paperwork in that case that has your signature on it. Before you signed it, did you go over it with Mr. Lewis?
Yes,
Do you fully understand it?
yes,
And do you understand, again, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
no objection.
It's admitted. Mr. Spikes, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in each of these cases. I'm handing you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff. Thank you, ma'am, for being here. Good morning. Are you Contasia Richmond?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Richmond, in cause number 24, DCCR 2306, you're charged with the state jail felony offense of theft with previous theft convictions from September 9th of 2024. The indictment alleges you were previously convicted of theft June 21st of 2019. And then after that was final, you were convicted of theft in 2 cases on the same date, March 21st of 2024 in Bell County, and then again April 10th of 2024 in McLennan County, Texas, and May 31st of 2024 in Collin County, Texas. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And are those prior convictions true?
Yes, ma'am.
What are the outcome of those last few, 2024 cases?
Judge, I've got the one with 2023, where she in Hayes County. Is that the one? I believe that. Is that
I don't even have a 2023 Hayes County in here. I've got
I've got
2 in Bell County, 1 in McLennan, and 1 in Collin.
Colin. We got 200 days in county jail,
Okay,
and let me pull the Bell County. Bell County was 9 months.
what about McLennan County?
It was 4 months. I think it was a misdemeanor. 4 months.
I believe
Okay.
most of these were punished as a misdemeanor, 1244, Judge.
Well, you've got one, the Bell County's out of a district court,
Yes, ma'am.
and the Collin County's out of a district court, which they could have pled them down, but those are both.
This is a state jail. The Bell County was the one in 2024. It's 9 months state jail. And the Collin County one, like you said. I know. The Collin County was a 1244 to be specific, Judge.
Okay. Let me look at something. I don't think I like it. God, these are so hard to read. I'm printing the PC. I can't see it. Okay, PC. So there's a case from 2017 here out of this court for a 2-year term in prison. What was that for?
No, I had 2 years probation, and then when I went to jail, I had got some jail time with the 1224 I don't know how much it was.
So What I'm looking at here, which is even more than what's included on that indictment, shows a 2017 conviction for theft here in Jefferson County, a 2023 in Collin County, a 2023 later that year in San Marcos.
Hayes
I
County.
was
Hayes
in jail
County.
that whole time.
I don't care if you're in jail. I care that you're continuing to.
Now the courtroom shifts, but the theme stays the same. Enter Contasia Richmond, facing a state jail felony theft charge with an extensive trail of prior convictions across multiple counties. And this is where the judge's frustration becomes unmistakable. County to county, year to year, conviction after conviction, jail time hasn't worked, probation hasn't worked. And the judge says it plainly. This isn't ancient history. This is recent, repeated behavior. From a legal standpoint, prior theft convictions elevate punishment ranges and reduce the court's tolerance for negotiated deals. That's why the judge openly rejects the proposed 12-month recommendation, not out of emotion, but logic. Sentencing is about deterrence, and if the behavior continues uninterrupted, the sentence must escalate.
Going to steal, and that I'm not sure that this deal that you've made is sufficient for what I think, for what you've been doing. So we're not talking about a long time ago. We're talking about the last 2 years. So going from literally from county to county to county. So we've got Collin County, Hayes County, then we're into 2024 where there's 3 convictions, one in McLennan County, one in Belton County, one in Kaufman County. And we're back here with an offense date. So the offense date here was 9/9, which is actually of 24.
Yes, ma'am.
Okay. So at least that one was before the Kaufman County. So you went from here and then you traveled to Kaufman County within 3 days, got another case there. Or at least you had it before and that was the conviction date. Yeah, nope. I will keep the paperwork. Y'all can go visit. I don't think 12 months is appropriate. Somewhere there's got to be a little more than that, in my opinion. Otherwise, obviously, jail time has not been sufficient to deter Miss Richmond from going county to county and stealing places. So y'all take another look at it. I won't delete it. So if y'all come up with something, I can make
What we witnessed today was accountability applied consistently across different crimes, different defendants, and different circumstances. In Mr. Spikes' case, the court made it clear that repeated violent conduct involving deadly weapons will not be tolerated, especially while on probation. The law responded with incarceration, deadly weapon findings, and permanent restrictions on firearm possession. In Ms. Richmond's case, the judge sent another message. Patterns matter. When theft becomes habitual and crosses county lines, leniency disappears. The court paused the process, not to excuse behavior, but to ensure the punishment truly fits the pattern. These cases remind us that the justice system isn't just about punishment. It's about drawing lines that protect the public. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe to Audit the Courtroom for more powerful, no-nonsense, real USA courtroom cases breakdowns.